Hey, Saturday afternoon. Carl Rominger here, going to answer your legal questions. 540-0580. Well, as you may know, if you follow me on Facebook, I was deer hunting last weekend, so there was a best of show, and I apologize for that. Sometimes I go live from upstate New York while we chase those deer around in the mid-afternoon, but we were going to hunt pheasants on Saturday afternoon, and I took advantage of that and got a few of those. So with that in mind, I'll promise to try not to do that again and take a day off, because why should I, right? I should be here every Saturday, 52 days a week, and so should Shane, and I'll make sure of it. 540-0580, call with your legal questions. I'll answer them here on the air. Well, you know, I was woken up this morning by my alarm clock, and there was a good old song on there, and I just want to play a little clip for you because you might recognize it.
The judge said guilty in a make-believe trial, slapped the sheriff on the back with a smile, said supper's waiting at home and I gotta get to it.
Now, you might know that song. You might recognize that clip. That's the night the lights went out in Georgia. And it says, you know, the fat-belly sheriff slapped the judge, and the judge said something about having to get home for dinner. I was in a trial one time where the judge called the jury out and told the jurors, much to the dismay of the district attorney and I, that it was Friday and it was getting late, and there were people over at his house, and his wife was cooking steaks, and he was wondering when they were going to finish up and get a verdict. And if you think I'm making that up, I'm not. I call it the steak charge. So this kind of stuff happens in real life. David, you're on with Carl.
Hey, how you doing, Carl?
Hey, my talk line number is 540-0580. David, what's going on?
Hey, I was just on a medical malpractice suit. Is that something that you guys cover through your?
We have, yes. And if let me put it to you this way: we keep some. And sometimes, depending on the exact nature of the incident, we farm them out to another practitioner who I like and who I work with, but to help me out, because there's certain aspects of the medical cases, if they get too technical or there's certain, infection issues, whatnot, I prefer to have this other fellow come in and advise us. But it doesn't cost the client anything, actually. You're basically two attorneys for the same price.
Okay. Is there a phone number to call you guys at the office if that's something up like that?
Yeah, it's 241-6070, and that's in the 717 area code, 241-6070.
Yeah, I've been dealing with a doctor that botched me, and I got a prescription and didn't tell me actually how to take it when I took it. I had a serious reaction to it and ended up in the hospital.
Ooh. Yeah, so you may have a claim. The problem with medical malpractice, and I'll warn you up front, is the damages have to be more substantial than not, unlike auto accidents where, I ended up getting an ambulance ride out of it, and I got a condition now that I'm going to probably have the rest of my life. Well, now you're in the scale where we do this. And I was just going to say, like in a little auto accident, like there's $1,000 in damage and you break your thumb or something, we can still recover substantial money for you. In a med mal, if you have a minor injury and then it heals, the doctors don't have to settle, and they don't like to settle because it goes on a permanent black mark on their record. So as a result, you can't often you're going to have to try those little cases, and we lawyers just don't want to pay all the expenses that it takes to do that. So minor medical malpractice claims.
Yeah, this has definitely destroyed my life. So like I said, I've got over $1,000 invested in it, just like I said, from my joyride and the ambulance and everything, but I have everything documented and everything like that, so I guess I can just go ahead and give you a call.
Yeah, it's 241-6070 at the office.
Thanks,
David.
Carl. I love your show, buddy.
Hey, thanks, man.
All right, take care.
540-0580. Fred, you're on with Carl Rominger.
Hi, Carl.
Yeah.
I have some money invested in a very low-cost Ginnie Mae fund, and I have for some time, and I'm not really concerned about the net worth of the fund. I am concerned about monthly income, and right now the net worth of that fund is at an all-time high because of low interest rates.
Okay.
And I could cash out and invest it in something else. But the question is what else? But anyway, I'm more concerned about my monthly income. Do you think I should just let it sit and it goes down in value? The heck with that?
Are you looking for Tim Decker, the guy that was on before me? He's the financial guru.
Oh, ouch.
But hey, here's what I'm going to do. If you hold on a second here. Let me see here. I'm pulling him up here. Listen, I do bring a financial guy on the show here pretty regularly, all right?
Yeah.
And that's Mark Virginis. And I'm going to give you a number. I want you to call him. Are you ready?
Sure.
509-4521. That's Mark. He's with Mirus Financial down in Lancaster. You can also access him under Friends of the Show on weekendappointment.com.
Okay, yeah, I guess I missed him by about 15 minutes.
But that's Mark's the guy that comes on my show and does our financial stuff, and he would love a call from you, I'm sure. It's 509-4521, and he can answer that question for you, no problems.
Thanks very much.
All right, no problem.
All right.
This is Carl Rominger answering your legal questions, 540-0580. Jerry. Hey, Jerry.
Hiya, Carl.
Yeah.
By the way, this is a great show.
Thanks.
Appreciate your service.
I try, and I appreciate you listening. I really do.
Yeah. Well, there's a lot to be said, and there's a lot to learn, but it's just a great service, too. I got a question for you. A number of years ago, I tried to get some information from one of the Pennsylvania departments, and that was before the Right to Know Act. Mm-hmm. But I was requesting under FOIA, the Federal Act, and they said there were certain things that were classified and you couldn't have access to them. Is there, with the current Right to Know law in Pennsylvania, is there a way I can ascertain their qualifications or how they classify classified information?
Yeah, you're talking about it at the state level?
Yeah.
Yeah, you may be able to do that. Now, here's the answer. I don't know a lot about the new Right to Know law, but we hired a new attorney recently in my office, Eric David, and I know he was already assisting some client writing a series of Right to Know requests to some poor local high school, and hitting them up on some stuff. I also know, because I talked to somebody who works in the government, actually somebody who works with somebody who works in the government, and they were telling us about how when they get their Right to Know request, they don't try to help you out. They have to be very carefully crafted. And if you ask the question the wrong way, they'll just say, well, we can't answer that. They don't tell you the reason they can't answer it is you haven't asked exactly the right question or an answerable question, or that you needed to be more or less specific. They just say we can't answer it. And then, of course, you have to appeal it to the office, Right to Know office. So I don't know the answer to that, but if you would post that on weekendappointment.com, little question, I will put Eric on it and have him give you an answer.
Okay, that'd be great, because I got a feeling that if you ask the wrong question in the beginning and you go to an appeal, they're probably going to – you still don't know the answer to how to ask the question.
Correct. And there's a format to it. And I think – in all honesty, I think what you basically end up doing is writing the question 5 different ways and saying, well, if this is what I mean. By the way, in case you're confused, this is what I mean. Just turn the words around a little bit and just make it
right from the beginning. You're saying,
yeah, right in the beginning, so that you line that question up very specifically, and break it down into its components, and then also add some, I want to say, legalese to kind of make it clear that, by the way, if your question is being read a certain way, it should also be read a different way as well.
Okay, and if you are turned down and you have to go to an appeal, is that sort of like a fair hearing? You have to have discovery and all of that stuff involved?
My understanding is that the records office basically then gets your position, gets their position, and makes a decision, and that either side's then free to appeal to a court if they're unhappy with that.
Okay.
But I'm just talking out my...
Yeah, no, but I mean, I hate to generalize, but the state is one place that... it seems to have a veil of secrecy.
And I can tell you that the new law really has put them in a position where they have to give out a lot more information than they ever had to previously.
Yeah.
They're not happy about it.
Yeah. I can see that.
And they go, like I say, in other words, there's nobody there with a smile trying to help you answer your questions when you send them in.
Yeah.
When the Right to Know request gets routed to somebody, if they can find a way to just dismiss it without having to answer it, they will.
Gotcha.
All right, Jerry.
So tenacity is involved then.
Yes.
Thank you, sir.
All right,
Have
take
a great
care.
rest of the day, too.
I will.
Bye-bye.
540-0580. Carl Rominger here answering your legal questions on WHP 580. I'll see you after the break. Oh, welcome back. 540-0580. And, oh, boy. Got some callers here. I'm going to take them here in a second. But, this has got me in a little mood here. Does anybody recognize this song?
Well, I decided to try in there. I'm going to do what's right and give her her fair share, right? But I didn't know it's going to be that much. Well, she got the gold mine. I got the shaft. They said they're splitting it all down the middle. But to give her the biggest half.
Anybody recognize that? Anybody recognize that tune from the day? All right, let's see if anybody knows. Hey, Tom.
Yes.
All right, you're on with Carl.
Good afternoon, Carl.
What's your question?
Well, it's maybe a lengthy question. I work for local government, and about several years ago, I was diagnosed with a heart condition, and I had to have open heart surgery. So my first surgery consisted of a replacement of a vital part in my body, which has potential of getting diseased, I guess. And in the midst of working at this company, I had received a pinprick, which caused significant amounts of blood. It was a needle, which didn't. Your first thoughts when that happened are, HIV, hepatitis C.
Right.
Well, the doctors are saying that that could have led to the demise of that certain part of my body, and it destroyed it, and which caused me a bout of endocarditis, which caused the valve. All right, I'm going to tell you, the valve that I had replaced. Or with my initial valve that was biological with a now plastic metal piece. And my question would be, if this happened several years ago, do I still have any recourse?
Well, did it happened at work?
Yeah.
Well, if it's related to a work-related injury medically, then it's a workers' compensation issue, and that would be your recourse.
7 years old.
How many years?
7.
Yeah, you probably only have a 3-year statute of limitations, if I had to guess.
Okay.
From the incident, 2 years for negligence, 3 years for workers' comp. What I would urge you to do is you might want to run in and see an attorney right away just to double check that in case somehow the statute was told for some reason, meaning that it didn't apply because you were unaware of the injury. But what I'm getting from you is you were aware of the injury.
I wasn't aware to the injury till recently. A doctor had told me that the reason why the endocarditis set in could have been from that needle prick.
Well, and then that's the question: is he going to say medically later it is or it isn't or it might be?
Okay.
Because might be doesn't get us very far in court.
Okay, so it has to be definite. Yes, it was caused by that needle stick.
In fact, I had a judge. I had a judge tell me this week, as I was arguing a sentencing thing to him, and I said something about, and if this hadn't happened, then that, and the judge says, stop. Have I ever told you the story of if?
Yeah. I know this one, I think. If ifs and buts were candy and nuts, it'd be Christmas, right?
Right. Or as he said, or if I was a horse was the story. His grandfather, he went to a whole historical family story, which was very, very, very interesting and amusing, and it was a point well taken. Of course, I was saying, but then I just had to shift tax a little bit. So, well, Judge, I wasn't offering it for that purpose, but yeah, that's a problem. If might doesn't get as far in the law.
Yeah, I think it would be a hard case to prove. In case can you really go back 7 years for that matter?
Yeah, and the answer is you can go back in time if the statute tolls and if you just realize. But a lot of times the problem is doctor will say to you, like, listen, this seems like it was caused by this accident or this incident. Mm-hmm. But when he's under oath and he's asked, can you say that to a reasonable degree of medical certainty, he'll look at you and go, no.
Yeah, then you're in trouble.
Then we're in trouble.
It's a huge waste of time. I understand what you're saying. I guess the question would be the fact that at that given time, and I guess till this day, there was no real way procedure, because I was doing a job that I shouldn't have been doing, or forced into a certain position where I would be administering certain things that wouldn't normally be allowed for me to administer.
Right.
And that's where the needle stick occurred, and that's the reason why I'm calling as well.
There may also be an OSHA violation of some sort, safe workplace. Again, I don't know what the time limits on that stuff are.
Yeah. Would it be worth maybe investigating?
Yeah, it might be worth investigating.
Well, appreciate your time, Carl.
All right. Thanks, man.
Thank you, sir.
540-0580, 540-0580. Robert, you're on with attorney Carl Rominger.
Mr. Rominger.
Yes.
How are you today?
Good. How are you?
Good. In 2000, I went into Camp Hill for a group home failure. I did something in the group home. Not bad, but I removed a couple of dollars. I was 5 years IP and sentenced to Camp Hill for 2 to 7 years to be warehoused in the state correctional institution.
Okay.
And then I dreamt in 2002 that the self-service lottery machine. And when I got released in I believe it was 05 of December, I did 8 years instead of 7. I wound up doing 8 years for no reason because of the mathematical error. And then my questions are, I invented a self-service lottery machine. My dad was dead about 5 years, and he came in my mom at Dempsey's restaurant, and I invented the self-service lottery. I said, Dad, when are we going to play the lottery? He said, what's that over there? I said, Dad, it's a self-service lottery machine. In my dreams, it was vivid as a picture. And I heard him talking. I said, it's a self-service lottery machine. So I wrote to Corky Goldstein for years and years. He couldn't get paid. I had $20,000 to start with in my bank account.
Robert, I'm not quite following you.
Oh, yeah, I invented the self-service lottery machine, and Mr. Gonzalez, his name's all over the computer. He was a psychiatrist at Danville State Hospital. I was sent after I did my time. He patented it.
Robert, I'm going to need. this is getting too lengthy for the air.
That's all I had to say.
I just need you to post this on weekendappointment.com, okay? Woo! Randy, you're on with Carl Rominger, 540-0580.
Mr. Rominger.
Randy, what did you invent?
Nothing, my friend.
Okay,
hard times. Thanks for taking my call. You helped me out the last time. I had a toolbox issue, and that worked out great. At any rate, what my issue now, my granddaughter is over in the Pittsburgh area, and at any rate, there was a court order where my stepson gets her every Tuesday and every other weekend. Well, now because him and her are fighting over a cat, him and his ex-wife, for the last 2 Tuesdays, she hasn't let him see her, or this weekend he was supposed to have her, and she's going against the court order. And I called some people, and they said, well, you got to file contempt of court, and you're going to need a private attorney to do that. And it just seems to me, she's violating a court order. Mm-hmm. Can't the police or anything do anything on that?
The short answer is yes, they could do something, although realistically we find that the police stay out of what they consider a civil matter, which is the violation of a civil court order.
Right.
And we see this also and it's not just child custody cases, it's land use as well. If you have an order that says the guy can't block the lane, the judge will say, well, the lane goes across his lane, or the cop will say, the lane goes across his lane. I'll talk with him, but, we can't really make him take it down. The court has to contempt him.
Right.
So, yeah, the short answer is you probably have to go the private contempt route. However, I can tell you that as part of that contempt route, you can sometimes get attorney's fees paid for, and we do that, depending on the county and the judge. And usually I tell people, even if the judge is pretty soft on them on the first contempt, second and subsequent contempts can be met with jail time.
Right. And the girl won't talk to me or my wife, but it's like, she got message to her that, you're in contempt of court and everything, and she's like, so?
Right. Well, and that's then now the question is, get her in front of a judge and let her say that. Right.
But so what I really do need to inform him is to somehow we got to find a private attorney and find a way of paying and go from there, I guess.
That's the best route.
Okay. And we called, a couple of the legal services, and they said there's no free help for contempt cases like that.
Correct. A lot of the free legal services will do PFAs. They'll do some initial custody work, but for the most part, they won't get involved in those issues.
Right. Do you cover Armstrong County at all over there?
No, unfortunately. Or fortunately, I guess, because that's quite a drive. Although I was in, believe it or not, Crawford County yesterday doing an ag assault charge. So.
Right. Well, alrighty, my friend. I appreciate the information, and I'll see what I can do.
The other thing you could do, by the way, is the glorified bluff, which is, of course, hopefully she's not listening to the radio show here today.
She's over by Pittsburgh.
Which is where you send the letter, from a guy like me that's local that says, I'm filing unless, with no intent to actually file, but simply to see if that doesn't straighten her out, because now she might not, realize that I'm not actually going to drive to Armstrong County.
Right. All right, Carl. I got your local number down in Carlisle. Let me see on Monday. Maybe I can get a hold of you. And
all right, Randy.
What I can do.
Thank you, my friend.
Thanks a lot. Bye.
Bye. 540-0580. Carl Rominger here answering your legal questions. In case anybody wondered, that clip I played earlier is she got the gold mine and I got the shaft, because, we split everything in the divorce. And sometimes things can be split right down the middle, and sometimes they can be broken up into their constituent parts. Bob, what's going on?
Hi, Carl. Thank you very much for taking my call. I had a question where my aunt's son passed away, and during the 100...
Maybe your nephew?
I'm sorry, can you hear me?
Your aunt's son, that would be your nephew? Your cousin.
I'm her nephew, right?
Okay.
Right, and so, I'm his cousin.
His cousin.
He said during the first 120 days, anything from his estate would go to a friend. Past the 120 days, it all would go to his mother.
Okay.
What if his mother passes away before his probate gets finished? Does all the
is the will say 100? It says if so and so predeceases me by, or survives me by at least 120 days, they get it.
They would get it, right? Like his mother would get everything. But what if probate hasn't been finished yet?
We don't go by the probate length. We go by the 120 days.
Say again?
We go by that 120-day period. So when I write a will, I would say, I leave everything to you as long as you survive me by 60 days.
Okay.
So as long as you survive me by 60 days, you get it. And if you die on the 61st day, you still get it. It just goes into your estate.
Ah, that's it. Okay. I was wondering if it would all go to her estate then.
Yes. If you die on the 59th day, what I wanted to do was to prevent one estate from dumping into a second estate, so I skipped it. Make sense?
Okay, I think I have it. In other words, if she dies on the, let's say the
119th day
time limit that he set,
right, 121st day,
her estate.
Right, and the reason we do that is real simple. Like, say you have a husband and wife. I leave everything to my wife so long as she survives me by 60 days. Otherwise, I give it to the kids.
Okay.
And the reason I do that is my wife and I die in a car accident together.
Okay.
Then I've left everything to another estate, and then that estate distributes it. Or if we're in a car accident together and she survives for 15 days on a respirator somewhere, and I die instantly, I don't cause it to jump from one estate to the other. I get straight line to the kids. So a lot of lawyers use 30 days, some use 60. 120 days is getting out there. That's a little longer than I would usually use.
Right. I was kind of wondering if it might revert back to the prior person.
It does not. It does not. It does not. The reason we use a 30, 60, or 120 day or whatever kind of interval is to push the risk of that out. But what we figure is it must have been his intent that his mother get it. He just didn't want his mother's estate to get it unless she survived him by at least 120 days.
Okay. Okay, great. Hey, well, thank you so very much.
Not a problem.
I really appreciate your help, and I love listening to your show.
Bob, I got a lot of practice with this because I write all those free wills for the listeners who go to weekendappointment.com and sign up for the free will kit. So that's an explanation I commonly give to folks when they sit in my office with one of those free wills about why we're leaving it 30 days or 60 days, a clause in there for survivorship. So I just want to remind everybody that the opportunity is there. Go to weekendappointment.com, click on the free will, fill out the kit, send it in, and I'll meet with you and give you a free will, okay?
Okay. Hey, thank you so much.
Thanks, Bob.
Thank you.
540-0580, Carl Rominger here on WHP 580. I'll be back after the break. Hey, Carl Rominger here, 540-0580. That's little Hank Williams Jr. doing Lawyers, Guns, and Money. And I always enjoy that song. Of course, as a lawyer, you know, you feel I'm right there with Guns and Money, apparently, which I like both of. So, hey, why not? I really like guns. Tom, you're on with Carl. Tom. Yeah.
Hi, this is Tom. So, you know, like, I don't understand. You obviously knew the guy who had a mental illness, and you just shot him off like he was just mentally ill, which is what happens so much these days. And then the comment you made when you hung up with him, I mean, anybody knows, like, he was trying to explain to you that a psychiatrist at Danville stole his patent idea. Like, this is why there's a stigma on mental illness in America.
Well, now, wait a minute.
Exactly because of what you just did.
Wait a minute. Are you sure Are you sure that the therapist stole his idea?
I'm not sure, but that's what he was explaining to you, and you just threw it off like he was a joke.
Did you get that, Shane, out of that?
I just find it very, working in the social work field, it happens so much, there's a stigma. And
now listen,
you didn't give them the time of day.
Listen, I give a lot of people with mental health problems the time of day. When they come to our office on a routine basis, we quite often will talk with them at length to ascertain if they have a real or imaginary problem.
Okay, well, that's fine. And I understand a lot of times, not even a lot of times, people just don't give them the time of day because they have a mental illness and they don't want to give them that time. And then your little comment when you hung up with them, you're like, woo, out of this world. I just find it very upsetting.
Tom, I'm not going to apologize for that because I don't know. I don't know if this guy's mentally ill. Or if he's one of the cranks that we get that call here from time to time that make it past the call screen.
But, like, you just shoot him down. Like, I'm just going to shoot you down.
You can shoot me down. I can shoot you down, too. My point is this. If he's mentally ill, God bless him. If he's a crank, then he hung up. He didn't want to. I didn't hang up on him, folks. Chad, you're on WHP 580 with Carl Rominger. What's going on?
Thanks, Carl. I have a question about the where I have a property at the homeowners association.
The HOA.
It's governed by other owners. It's not a management company. And turning the property over to rent it again. And I walked in just to check the place out, and there's a new governance book sitting on my counter. And for what I noticed about it is that evidently there was a letter with it saying that there were some changes made and amendments put in. I don't know what those amendments were because they weren't listed. And what I find out about it is that, let me just say, the first original book that I had was the original document from 1989, and it was copied in a book which was distributed to everybody. Mm-hmm. The new one was typed up again. Very neat. And then at the end of the document was clipped from the original document from 1989 with the original notary and signatures on it from then. That hold, or?
I don't know. It sounds a little unusual to me. The answer is we'd have to go through the process. I mean, they must have bylaws on how to change their governance documents.
Okay.
So the question would be, can they show or can they prove that they've gone through the necessary steps and votes to change those things?
Okay.
And a well-run HOA will have all those records.
Okay.
All right?
Thanks.
No problem. Yeah, I don't think you can just clip some old signatures on there. I mean, it doesn't mean that the new regs aren't valid. It just doesn't necessarily mean it was done right. And, of course, if it wasn't done right, they might not be enforceable. And, of course, if you really want to have some fun with HOAs, call Bob Durgan sometime. He seems to really like them. Richard, you're on with Carl.
Yeah. Yes, Carl. I was involved in a criminal activity about 45 years ago, and I was just wondering if there's anything that I can, I could talk to the individual and I talked to her and said what I'd done, I was sorry for it and stuff like that.
Right.
And she said, well, okay, don't worry about it, but won't worry about it no more. But it seems like the local populace, the neighbors and stuff like that, kind of constantly harassing me all the time. Is there anything I can do about that?
They're harassing you about the old criminal offense?
Yes.
The short answer is harassment is a communication that serves no legitimate purpose with the intent to harass you. I mean, I don't see what the legitimate purpose of them harassing you about it would be, so you may be able to do something. If you came to see me, we'd start by writing them all letters, asking them to cease and desist, and also copy it to the local police force, and go from there.
Well, maybe I'll try out. I don't know. I'll have to figure out what I'm going to do.
Understand, Richard, and I understand it can be troubling. You know, my advice to your neighbors and the people who are hassling you is if you were in trouble 35 years ago and you haven't been in trouble since, then those who live in glass houses shouldn't throw stones because nobody's perfect.
That's exactly what I was trying to say myself.
Yeah.
And I've been leading mostly a pretty upstanding life the last 45 years, plus I have children and everything else. I don't think it's fair that I have to pay the rest of my life.
And listen, I'm a firm believer in that there's a very easy thing that people say out there was, well, he did a crime, he does the time. And I go on huntingpa.com, and there's all these whack jobs on there who think that everybody who makes a minor violation of the game law should be hung and strung and lose their gun rights for life. And or if they make a more serious offense, then they should be executed and lose their gun rights for 2 lifetimes. And I try to explain to these guys that, you know, you have to punish people, but you have to recognize that they also can get better and that they can also change, and you can't just handicap people's ability to live their life forever.
Exactly.
So, Richard, I'm on your team, buddy.
Thank you.
All right, take care.
All right.
540-0580. Tim, you're next. Hey, Tim.
Hey, I liked your video on there. It was pretty good, your DUI.
Oh, you like that?
Yeah. I had a question. I was just looking over some legal paperwork here, and it says that if you decline to have a urine test during a checkpoint, that you lose your license for a year, but even if it comes back that you're not intoxicated, that you still lose your license?
If you refuse.
If just because of the point that you refuse it.
Yeah, there's a civil statute in Pennsylvania that says that PennDOT can take your driver's license for refusing an official blood, breath, or urine test. Officer chooses the test, by the way. However,
I just found that ironic that, if you weren't guilty, it just goes back to the harassment of, them doing it, what you went through.
It's called implied consent, the idea that you've implicitly consented. Now, here's the answer. They still have to have a reasonable basis to believe that you were DUI, and the Commonwealth Court has interpreted that basically to mean that the police officer can articulate any reason whatsoever. That's the way I would interpret the case law.
I was just trying to dot my I's and cross my T's for all these people. I know a lot of guys are trying to play a hardball because of the violation and the harassment.
Here's what you do, and if the video you're referring to, by the way, in case people want to know, you can go to weekendappointment.com and find it on there. It's a video of my own DUI stop from June of 2009. Although I wasn't DUI, I call it a DUI stop. So whatever idiot out there is going to write me an email and tell me shame on me for putting the community at risk by drinking and driving. I'm not guilty. Remember, until proven so.
Did they give you the key to the city though? That's all I want to know.
Yeah,
no.
No, if you listen to the video, in the middle of the video, you can hear him griping about me.
Oh, I know, I heard that.
But here's the answer. If you watch that video, and you have to be very careful, they wanted me to take a portable breath test. You do not have to take the portable breath test, folks. If, on the other hand, they ask you to take an official breath test, an official blood test, or official urine test, you have to submit. So when you're asked, you should be very careful and say, are you asking me to submit to a portable breath test or an official chemical test?
All right. That's what I just wanted to verify that for all your listeners so nobody hung themselves by doing something stupid. Yeah. That was an awesome video, Carl. I'm glad for you fighting for the rights. That's awesome.
Yeah, and I got a couple other videos I put up there that aren't mine, but they're one's a great law professor and police officer basically talking about how, like, by talking to the police, you get absolutely no benefit whatsoever. And it's amazing because I have clients that have been arrested twice or 3 times and got themselves hung up by talking to the police the first time, and they still talk the second time. They're like, well, I was nervous, Carl. And I'm like, nervous? Shut up.
Right. All right, brother. Hey, man, keep up the work.
Thanks, man.
Bye.
540-0580. I'll see you after the break. Hey, welcome back. Carl Rominger here. You saw this WikiLeaks documents coming out on the war in Iraq, and I think one of the more interesting things that you're going to find in there, I'm crinkling my newspaper here, is according to the Patriot, Iran's military, more than has been generally understood, intervened aggressively in support of Shiite combatants, offering weapons, training, and sanctuary, and in a few instances directly engaging U.S. troops. And what did our presidents, and I don't say president, I say presidents because I think it was Bush and Obama, have done nothing about that. But you can, Iran, you can shoot at American troops. You can. You're allowed to do that. Sue, you're on with Carl Rominger. How are you?
Okay. I have a question about my health insurance plan.
Yes.
My plan has between the deductible and the out-of-pocket expenses, supposed to be like $4,500, and I made that back in August.
Okay.
And since then, I had some tests done and stuff. And they paid 100%. All of a sudden, at the end of September, I'm started noticing I was getting a explanation benefit saying that I still owed almost $500. Went back checking, and it appears that they took money back from the hospital and took that out of my out-of-pocket expense cap. And I had already paid the hospital bill and everything. And I'm just wondering, can they do that? And do I pay wait and see. It's in or what is it called, appeals now.
Right, arbitration.
Yeah. I'm on the first level of it and stuff. And when I talk to the lady, they can't figure it out either.
Well, I guess I would talk with the hospital, and as long
yeah, I've already talked with them, and they have no record of any money being taken back.
Okay.
So it's one big confusion. But these doctor bills that are coming in now, I said, do I pay them or do I wait and see? Or
I would just alert everybody that you're tangling with the insurance company here, and you're trying to figure it out, but of course you'll pay them.
Yeah.
On the other hand, if you have enough cash laying around that you feel comfortable paying them, and then waiting for that to get untangled, you could do that as well.
Yeah.
My usual position would be to just go ahead and say, hey, I'm going to hold off paying this until we figure this out, unless one of the doctors comes to you and says, I really need paid now.
Yeah. As I know, I've been talking to some other people that work from where I work and have the same insurance stuff, and they're having the same problem too. That they're taking the money back a couple months after the bill's been paid and stuff.
Right.
So as I don't see how the insurance company can do that, but
right, and it sounds like everybody's confused, and it's going to take a while probably for record keeping to catch up.
This plan's one that Obama really praised.
Yeah.
So I said I don't have too much praise for him.
Yeah, I understand.
But okay.
All right, Sue. I guess my thought on the matter is let's see if it can get straightened out on its own.
Okay.
Sometimes, like I said, the left hand and the right hand don't know what they're doing.
That's what it sounds like, because they told me what was paid. Oh no, it was denied and stuff. So.
Right.
Okay.
All right. Take care.
Okay. Thank you.
That doesn't sound like a legal issue yet. It sounds more like a practical question. Let's see here. Ann.
Hello.
Hello. You're on with Carl Rominger. What's going on?
This is Ann.
Yes, Ann. What's going on?
I received a letter in the mail. Well, I was married to a military man for 38 years, and he passed away just very recently. And I've been getting payments from the military under the Former Spouses Protection Act since 1991. And all of a sudden, this letter says no further funds are available to the member's death. And I don't know how I'm going to survive. I'll probably go down the tube.
Okay. So they're saying that you're out of money.
They're saying that no further funds are available due to the member's death. But this is from the military. They've got funds.
Yeah, and the short answer is we'd have to look at it. What you're entitled to is going to be based on what was the original benefit. So if there's no survivor's benefit, or if the survivor's benefit's exhausted, then there won't be additional funds. I would encourage you to get that letter to somebody to look at.
Okay, well, there are survivor's benefits.
Right.
But, the fact that they're going to chop out all of the money that is directly deposited every month,
right,
I'm really going to go down the tube.
Yeah, so we would need to look at that and see. I mean, I can't tell you without more information what's really going on there, okay?
Well, what would you suggest I do then?
I would suggest you get that letter into an attorney or a financial advisor right away.
Okay.
All right?
All right, thank you.
Thank you. Yeah, that sounds like, again, not quite ready for the lawyers yet until we figure out what's going on there. Maybe she has a claim, maybe she doesn't. Jason, you're on with Carl Rominger on WHP 580. What's your legal question?
Hi, Carl. Hey, I just wanted to give another quick plug for your website. There's a lot of good information on there, specifically the video of the law professor. Just had a follow-up question to that. He talked a lot about the jury perception, how you're sitting next to a defense attorney, and so that's going to play into what they're or how they judge.
Right.
And I understand that your Fifth Amendment right, you don't have to say anything to the police, but is that going to play against you in the jury's mind, or is there some sort of a legal safeguard?
The short answer is the judge is going to instruct the jury, if you want him to, that you didn't have to talk and they can't hold that against you. The flip side on that one is obviously some jurors are going to hold it against you. I get so mad at jurors when they tell me afterwards, well, I didn't hold it against him, but I would have liked to have heard from him. Right. Yeah, well, then you did hold it against him. But more importantly is this. Your pre-arrest silence or your post-arrest silence can't be commented on, argued, or highlighted to the jury. So if you do take the stand, the government can't say to you, well, you didn't say this earlier, or you never told us this before. It can't do any of that. So you're the best of both worlds is at the end, if you haven't talked before and you do talk, the jury's not going to find out whether you ever gave this story before, and the police officer's not allowed to do anything, or the district attorney's not allowed to put in anything that would lead the jury to believe that you didn't talk or that they didn't have this information ahead of time. So because that would be commenting on your pre or post arrest silence, and that's illegal. So there is some safeguard there. There are times, however, you can't put the client on the stand because there's some other reason besides some evidence that might get in that's not relevant to this crime, but you don't want the jury to know about it or something, so she can't take the stand. Sometimes they don't want to take the stand because they're just too nervous or upset, or sometimes they don't take the stand because they talked to the police already and they feel that their statement's going to be the same, so why subject themselves to being yelled at by a district attorney in an accusatory nature? So there's a lot of thought goes into that. But I can tell you, I usually prefer to put a client on the stand if they're willing to do it, and I find that that's the best, because really the jury does need to hear from the defendant, because it's hard for them not to hold it against them. But I think the only time they should ever hear from the defendant is at the end of the trial, not sooner.
Okay.
All right? Thanks for the plug. Weekend Appointment. We've got quite a bit of little tidbits up there, and we're going to keep making that a better website here. So,
excellent.
Thank you, Jason.
Thanks a lot.
Bye. Let's see. Who's next? Jenny, you're on with Carl Rominger. Hi, Jenny.
Oh, Jenny. Hello. Thank you so much for this service. I did have a quick question just about a medical test that I thought maybe should have been done. Is that appropriate to speak with you about?
It is if the test. I mean,
it's a blood test.
Right, and the short answer is, if a doctor can say that the doing of that test would have changed an outcome, then it is medical malpractice. Here comes the music. I got to let you go.
Thank you.
Oh, all right, guys. I'll see you next week. In the meantime, go to weekendappointment.com. Don't forget to get on there and get your free will. And, of course, my contact information, if you want to see me throughout the week, you can do that there as well. All right. Thank you.